Welcome, everyone. Very happy to be talking once again to Andrew Weissmann today. As I'm sure many of you have already read, remarkable reporting from the New York Times that a federal grand jury, has refused to indict the man seen in that viral video throwing a sandwich at a federal agent. And absolutely remarkable. Before we start the conversation, I want to read this statistic that a Washington Post reporter put out there today. This is from 2009 to 2010. Federal prosecutors pursued over 160,000 cases, and grand juries only voted not to return an indictment in 11. As everyone knows the saying, a prosecutor can indict a ham sandwich. Not in this case, and this is the second time that Jeanine Pirro has failed to secure an indictment in recent days. And the viral video speaks for itself. You see the guy doing a wind-up and throwing the sandwich and running away from law enforcement. No bill. There's no indictment on that. So to unpack what that means, Andrew Weissmann, a few people have had the kind of view inside the Justice Department, FBI, as you have. Walk us through the grand jury process and why it is so difficult, usually, for there to not be a return on an indictment. Why it's so rare, I should say,
Yeah,
that there is a no bill. Walk us through that process.
sure. Happy to be here, and thanks to everyone who's joining in. Uh, when I started my career, I was an AUSA, an assistant United States attorney that was a federal prosecutor in the Eastern District of New York that covered Brooklyn, Queens, Long Island. Especially in general crimes, your first year there, I mean, you're in the grand jury all the time. But then as you get more senior, I dealt with sort of normal grand juries and then also what's called special grand juries. A special grand jury might be for the Gambino family or the Columba family, or a special grand jury to investigate the Enron collapse. Or in the special counsel Mueller case, you could have a special grand jury. So you have grand juries all the time. And federally, in order to bring a felony, that is not up to a prosecutor and at the ultimate decision. It is a grand jury that has to charge, absent the defendant agreeing to forego a grand jury indictment. In other words, to be charged federally for a felony, the grand jury has to vote it. That's not true, by the way, for a misdemeanor, which carries a term of only up to a year. I shouldn't say only. I mean, one day seems too much, but for a misdemeanor, there are different rules. But for a felony, a grand jury has to vote the indictment. What is a grand jury? A grand jury is made up of people just like a petit jury. The same pool of people who could be on a trial jury can be on the grand jury. And a lot of times you get a notice, and it turns out most of the time it's for being on a trial jury, but every now and then you get a grand jury one, and that could be for a month, or 2 months, or 3 months, or in a special grand jury, it could be up to, wait for it, 3 years. So I know some of you are going like, how do those people do their jobs? But in any event, you get your notice, you go through some selection process, which is only with the judge, and a prosecutor is sort of present. There's no defense lawyer because there's no defendant. And so the prosecutor is sort of there just to sort of to sort of chaperone the people, but the judge just makes sure that the people can be fair and impartial. And the judge chooses 23 people. There cannot be more than 23 people, and a grand jury is supposed to have a group of 23 people. In order for the grand jury to function, when they're now selected and they're part of the grand jury, you have to have 16 present. And so let's assume the full 23 are there, and the prosecutor can come in and present a case. And in order to get an indictment, two things have to happen. One, there has to be a vote of a majority of the 23. So 12 people, not unanimous, not 22 or 21, only 12. So you only need 12 of the 23 to indict. The second thing is the standard. The standard is not the trial standard in a criminal case, which is beyond a reasonable doubt. This is just deciding whether the case should be indicted and then go to trial. And so the standard is really low compared to proof beyond a reasonable doubt. It's probable cause. There are a number of reasons, as you can imagine, why you rarely, in my experience, I've never ever even heard of a no true bill when I was trying cases and presenting cases in the grand jury, and that's because it only takes 12. You only need probable cause. You're not going to present a case to the grand jury unless you have tons of evidence that you think you can win at trial. Remember, you don't wanna indict a case if you don't think you can win beyond a reasonable doubt, because what's the point? You're gonna have an indictment, and then you're gonna lose. So, you go in with much more evidence than the standard that's needed. There's no defense lawyer there. There's no legal obligation to present exculpatory evidence. Supreme Court, God bless their souls, said the prosecutor does not. That, by the way, that was sarcasm. In case you couldn't tell. You don't have
Yes,
to present
absolutely.
that. So the final thing is, when you have a case that you think might be close, or you think that the grand jurors might have questions, you can present the case. You call an agent. You can call witnesses. You can present documents. And you typically, before you leave the grand jury to vote in secret, that everyone leaves, except the grand jurors, the court reporter, the prosecutor, you all leave the room and the grand jury votes secretly. And then you're invited back in and they tell you true bill, meaning there's an indictment, or no true bill, there's no indictment. And what you do is you read them. You go over the facts with them that's been presented by usually by an agent, like an FBI agent. You tell them what the law is. All of this is recorded by a court reporter, and you ask them whether they have any questions about the facts or the law, and you answer those questions if you can, or if you need to call other witnesses to answer the questions, you can do that. But one of the things you can do, which I would typically do, is say, look, I'm going to leave you to deliberate. If, as you deliberate, you've got additional questions that you think I could answer, if there's additional evidence that you're looking for, questions about the law, feel free to invite us back in the room, the agent and me, and we'll come in and see if we can answer your questions. You know, I can't off the top of my head think of when that has ever happened. But the point is that it's such a low standard that you only have to have a certain number of people. Usually have developed a perfectly good relationship. You're trustworthy with the grand jury, and so um, it's just so. I mean, to say that it's rare overstates it. It just doesn't happen. The only time I have ever sort of read about it is where a prosecutor may not want a true bill, in fact. Like, so there was a problem in prosecuting, or certainly in state cases, where prosecuting police officers, where a prosecutor might like say, oh, well, we presented it to the grand jury, and then the grand jury wouldn't do it. And meaning it's not us, it's them. But you sort of wonder what was really presented to the grand jury. Was it sort of presented in a way to get the no true bill? And that would be my question about the 11 statistic that you started with, Adam, which is
Right.
I wonder if any of those could, I'm not saying that happens often, but I wonder if any of those could be explained that way, because it's just so rare to have that happen. The one thing I can think of is reportedly, I think Andy McCabe, the former acting director of the FBI, who was being investigated under the Trump administration, Trump 1.0. I think there were reports that the grand jury refused to indict there, saying that there was not probable cause. And that's one where I would suspect that the prosecutors wanted an indictment, and the grand jury thought there was not sufficient evidence. I would assume in that case, That, and again, this is surmise, that they didn't think there was enough with respect to intent, that there was an intent to mislead, like even if he said something erroneous. But anyway, that's all speculation. But it's just so rare. And it's such a sign that you have an administration where this has happened, and it's a real sense of overreach that the community is reacting to.
And to your point, there it's very interesting. There was a case in Staten Island, in New York, about alleged police misconduct, and that came up about whether the grand jury transcripts would show an intent to try to leave the officer without an indictment. It's one thing. So to talk about these two cases, because these happened in rapid succession under Janine Pirro's tenure, where she has been unable to secure an indictment. And this one is a viral video we've all seen. The guy winds up his throw. He throws the sandwich and runs away. I'm assuming that they tried to presumably deployed this statute: assaulting, resisting, or impeding certain officers. Someone who forcibly assaults, resists, opposes, impedes, intimidates, or interferes with any person designated in section 1114 of this title while engaged in or on account of performance of official duties. It's a pretty broad statute. And what do you get the feeling of it? Was this grand jury nullification that they just thought that this was too harsh a statute to have a felony charge out there for what we saw in the video, that a grand jury just thought it was overkill?
Um, so, by the way, you probably know the answer to this, but I read reporting that this, with respect to this particular matter, that this may not have been the first time that they presented the case. I think I read that this may have been the third time they tried to get an indictment. I don't know if that's true
In
or not.
this case,
Yeah,
in this case, you're saying, yeah,
yeah.
that's quite possible. That I
So,
know that in another grand jury matter, there have been multiple attempts
right.
as
So,
well.
So normally, I'm going to answer your question, but just to normally, if a grand jury in the rare instance decided that there was not probable cause, you are legally allowed to represent the case to a new grand jury. But the Department of Justice, and certainly I understood that you'd have to go get very high level approval to represent a case. I had read, and again, people should, I could be wrong, that this was that three grand juries refused to indict here. Now, I want to make sure people understand the reason I'm resisting the idea that this could just be grand jury nullification is grand jurors, like trial jurors, take an oath. They raise their right hand. I've been on a jury, a civil jury. I'm sure many people who are listening have been on juries. And you take an oath to obey the law and to follow the law as stated. You can't just say, I don't like the law, I don't like the case. You have sworn to that. I always tell this story in the Manafort criminal trial in the Eastern District of Virginia. The only juror who talked afterwards, and there was a guilty verdict on, I believe, about 8 of the felony counts, and a hung jury on others. He later pled guilty to admitted that he did those. But in any event, the one grand juror the one trial juror who spoke said that she had voted for Trump. She had a MAGA hat that she said she literally left in her car, and she was like, "He was guilty, and I have a word for I have something I wanna say to the president, which is he should not be pardoned." And the point is that the jurors and grand jurors, I can't say invariably, but my experience is, take their oath seriously. And so I think I would resist the idea that 3 separate grand juries, let alone 1 grand jury, made the decision that they just didn't think it was a good use of, resources, that this was overkill, all of the policy reasons why you would not bring this case, right? Like, in other words, if we were sitting in the Department of Justice, you would be like, "You know what? a death ticket is enough, or the fact that he was arrested, that's enough. I mean, like, it's a sandwich for God's sake. So it's just not a wise use of resources or prosecutorial discretion. But that's not the role of a trial juror or grand juror. And I suspect if it really did happen 3 times, that I can't say, I don't know for sure what was in each of the grand jurors' heads, and maybe some of them, certainly in the back of their head, thought that. But you could imagine many of them just thinking that you didn't prove a requisite intent to
Mm,
interfere, that you weren't trying to hit them as opposed to just throwing it generally in their direction, that it wasn't trying to obstruct the investigation, you weren't trying to hurt anyone, and probably looked at the elements that were set out, the elements of the crime that were set out by the government, and said, I just don't think there's probable cause here with
mm,
respect to various aspects of it. It is also possible, I don't know this for a fact, but a defendant, a putative defendant, someone who's being investigated, does have the right to testify in the grand jury. I don't know if that happened here, but we can relate that to when Donald Trump was being investigated by the Manhattan District Attorney's Office. He was given that opportunity, and he actually wanted the Manhattan District Attorney to call, I think it was Mr. Costello, who then was put in the grand jury at the request of Mr. Trump. And so there could have been contrary evidence as well that cast doubt on that. That's just a long way of saying that I really like to not be sort of holier than thou and think I know more than jurors and grand jurors. And just like I would take my oath seriously, I start with a presumption that that's what they did, and
mm,
I don't see why I should be so presumptuous of thinking they wouldn't do what any principled person would do, and if they thought the evidence was there, they swore that they would do it, and if they didn't think the evidence was there, they're not gonna, vote a true bill.
mm.
So, can I say that that's true? I don't know. Can I say that's true for each and every one of the grand jurors? I don't know, but I guess I would caution people to accord their fellow citizens the respect that they took this seriously and did their duty as they swore they would.
That's a very good note of caution. I mean, the only folks who know what happened in that grand jury room are the grand jurors and the government, and maybe the government just did not meet their burden. That it
And by the
wasn't
way,
that,
just to be clear, the government doesn't know. The government was not present
right.
when the deliberations happened. It is only the grand jurors. So the only people who know what the reason is and why they did what they did should be, unless they told unless the grand jurors told them, the government, is the grand jurors.
Mm. And let's talk about the other case too, because these were at least two that we know of that became known on the public record. There was a case of Sydney Reed, and when in her case, when the statement of facts in her case show an officer's lightly scratched forehand, that the government claims that she had assaulted the officer while resisting arrest, that the hand was pushed against a concrete wall. And one thing that jumped out at me in that statement of facts was that the entire counter began when she was recording law enforcement. And we've seen this kind of come up against and again, where law enforcement, people have the right to record encounters with law enforcement, but it sometimes is met with retaliation. To your point that grand jurors take their oaths seriously, do you think that in this particular case, that they thought there was more to that hand bruising than met the eye?
So I know just from what I read about that case, I'll tell you what I was concerned about, and I don't know whether the grand jurors did, but I would not have looked at that in isolation. What I understood from the reporting was that that was a larger context where there was touching or more than light touching of the putative defendant, and so this was in reaction to that. That to me would have raised substantial issues about intent, about whether in reacting to it, whether the agent then inadvertently led to that agent's hand being touching, being grazed against the wall. I mean, it just to me the context of that seem to raise substantial issues. Like I think of it when I think of it, I've been a defense lawyer, I've been a prosecutor, and so you think about you've got to understand what are the strengths of your case and what are the weaknesses on both sides, and so that sort of jumped out at me. I do want to raise one issue there, which is the irony of something that Pam Bondi, the Attorney General for the United States, said, and I'm gonna be paraphrasing. Nothing I've been saying is like a direct quote. But
Right.
she basically said, "You put a finger on law enforcement, we're going to come after you and throw the book at you." This is from the administration that pardoned each and every one of the people who was prosecuted in the January 6th case. And a number of those people assaulted Capitol Police. Um,
Hundreds.
how does that statement I mean, I was just like I mean, Nicole Wallace has said this when at one point I was saying, "Well, there's this irony or this hypocrisy," and she was like, "Andrew, that is long gone." Like, I mean,
Right.
but it's the point is that is just unbelievable. I mean, it takes enormous, as we would say in New York, chutzpah
What's the
to say that. And, with a straight face that you're sitting there going, you take assaulting a police officer seriously? I mean, I was in law enforcement for over 20 years. I take that seriously.
Right.
And where there's intentional conduct assaulting a police officer, state, federal, local, that is serious. These are people who put their lives on the line to keep the country safe. They obviously shouldn't be assaulted. They shouldn't be threatened, which, huge issue right now. And so I take that incredibly seriously. That is why people who have assaulted the Capitol Police while our country was experiencing a sort of mini revolt, insurrection, whatever the label you want to call it, it's just this it's beyond the pale. And so um, again, I don't think that the grand jurors were thinking that, thinking, "Oh, here's they." I mean, I don't think they were thinking of it as a reason to not vote one way or the other. At least that's what I would assume. It's there. The reporting suggested to me there would be a number of issues that would raise a real problem. And also, it's like such a it shows such um, lack of sophistication and poor judgment in terms of having an adult in the room.
Right. And lack of credibility now with the Department of Justice. You were mentioning the pardoning of more than 100 riders who were convicted and pled guilty to serious assaults with pepper spray, chemical spray, any object they can get their hands on. There's been a number of cases now across the country where there have been accusations or even indictments on allegations of assault. One was supposed to happen today in the case of Congresswoman LaMonica McIver. And she says that the hearing was postponed because she has brought a selective prosecution motion based on that very argument, the January 6th rioters being pardoned, and also some information that she got from body cam videos during the incident at the immigration facility in New Jersey, where she says that she heard on the body camera an officer saying that the mayor of New York was being arrested on the orders of the deputy attorney general, Todd Blanche. How does that
I
kind of
think
fit
I think
in?
I think you may have said mayor of New York, or
Oh,
did
excuse me,
I?
Newark. I meant to say
Okay,
Newark. If I
okay,
Yes, in Ross Barack, I meant to say.
yeah.
So what does that how does all of that fit in? We've seen this in Southern California. We've seen this in New York as well with the New York City comptroller, Brad Lander. They accused him of assault while wrestling him to the ground, and the video shows nothing like that. What does this say about the loss of credibility of the Justice Department that these cases are being no-billed?
Yeah. So, I was going to react to this issue of the potential that the deputy attorney general was the one who had to sign off on going forward. I'd say there's good news and bad news there. I have no issue when you're talking about the arrest of a political figure, of making sure that senior, experienced um, people are weighing in on that decision. I want to know that somebody like Bob Mueller has assessed this and is decided that it is appropriate to go forward and has thought about this in terms of can you make the case, but should you go forward? That's the more, there's two issues when you're a prosecutor. It's not can you bring a case? Is the proof there? Does the law support it? It's should you. That's the harder one. And so I have no problem with the idea that in certain cases you want senior leadership to be displaying oversight. That's in some ways, the good news. The bad news is that he said yes, because it just, again, I don't, I'm, the facts will come out and there'll be hearings and we'll know more. And so, subject to that caveat, which is an important one, um, from the reporting, it just seems like a complete overreaction, and it seems politicized. You just can't imagine that this would happen if the putative defendant were a MAGA loyalist. And it's not like me just speculating. We've seen over and over again targeting of Democrats and basically a green light with respect to friends and family, essentially, of people affiliated with the administration, which is antithetical to the rule of law. I mean, that is exactly what the rule of law is supposed to be against.
Right. And in LaMonica MacIver's case, Congresswoman, uh, the precipitating arrest, the arrest of Newark Mayor Ross Baraka, that case quickly disintegrated and was dismissed. He is now suing Alina Habba. Her case is pending. She says that the body cam videos that she received, rather than the edited ones released by the Department of Homeland Security, are exonerating. We'll see that process, how it plays out. That's happening in the District of New Jersey, and just kind of a related pivot. Alina Habba was just ruled by a federal judge over in the Middle District of Pennsylvania as being essentially having been in her post illegitimately since July 1st. It's now in the Third Circuit Court of Appeals. It just came out in one of the briefs there just how much criminal cases have snarled to a halt in the District of New Jersey, that 12 district judges have delayed proceedings. There have been 3 trials delayed, at least, several guilty pleas delayed, sentencing proceedings delayed, and that was before the ruling that she was unlawfully appointed. What does it mean that the Trump DOJ is going all out to try to restore her to this position when this is the effect in the District
Yeah.
of New Jersey?
So, Adam, wonderful point, because again, if you say that you're really concerned about law enforcement and combating crime, which, by the way, is the ostensible reason for militarizing LA and DC, and the recent executive order saying that which, by the way, that executive order starts by saying it's about DC, but it actually says I want a creation of a national force to be used at my discretion nationally. The "my" being the president, and this is antithetical to that. I mean, the reason that the judges, and I would assume with the prosecutors' acquiescence, are putting things off is because they don't want to jeopardize those cases. They want to be able to, if these are criminals, and presumably they think these are people who deserve to be punished, to have their day in court, and they want to find them guilty, and they want to go to sentencing, and they don't want to have that jeopardized by them the defendants being able to make a motion saying this whole thing was illegitimate because the U.S. attorney shouldn't have signed the indictment, shouldn't have overseen the case, all of that. So all of that is being put on hold. The big picture here is I want to make sure people understand the reason that you're seeing all around the country judges saying we're not going to sort of reappoint the Trump selectee is that is so unusual in every Democratic and Republican administration in which I have served, and it's basically all of them, since I was, since 1991. Um, the judges will just if the nominee hasn't been sort of confirmed in 120 days, they just go ahead and say, okay, fine, now it's our turn to after 120 days, we have to make a decision. We're just going to select the person who the president is nominating. And they do that because even though they may disagree on a whole bunch of policy issues, you may have Democrats who are saying, I don't think it should, I disagree because they have views that I think are more like Republican or Republican and Democrat, the vice versa, or a whole mixture. That's irrelevant. I mean, usually the people who have been selected are qualified. And here, the thing that I think is the big take home is not a legal issue. It's that what this signals is that it's not just Alina Habba. This is happening in a variety of U.S. attorneys' offices where judges from all stripes, all sorts of different presidents have appointed them, are saying no because you've selected somebody who is not qualified. And that's where you end up with Pam Bondi saying, oh, I think all these judges are political. Really, all of them. All of the judges, the ones who were appointed by Reagan and Bush 1 and Bush 2, they're all out to get this administration, and then suddenly they're like as soon as you rule against them, you're just you're suddenly an MSNBC like ultra liberal. I mean, it's fanciful.
Right. And this is happening, as you said, all around the country. There are at least four districts: Northern District of New York, District of New Jersey, District of Nevada, Central District of California. And that can be the result, where we can see criminal cases snarled because Trump is insisting on keeping his loyalists.
Keeping his loyalists, but to be clear, against sort of, at the very least, the spirit, and one judge has said now against the actual law, and that is that a U.S. attorney is nominated by the president, but needs to be confirmed by the Senate. And what the president is doing is a sleight of hand to say, I'm going to first nominate, and then if they don't get confirmed in 120 days, I'm going to do these machinations that allows them to essentially be there and be the U.S. attorney in effect, but never have to go through Senate confirmation.
Right.
And so that's the real that's really what's going on. And what's so ludicrous about this is if you just selected somebody who was competent, you'd have no problem. And just to be clear, in the Southern District of New York and in the Eastern District of New York, those are examples where the judges have said after 120 days, they have said with respect to Mr. Clayton that he has now been appointed by the court after the 120 days. And with respect to Jonas Sella in the Eastern District of New York, they have done the same thing. Why? Because the judges there made a determination that these people are competent. It doesn't mean that they agree with everything they're doing, that they would be the person they would choose, but they understand that's not their job, that's not their function. But when you are Alina Habba and you have no experience in criminal law, where you announce that when you take the position that you're hoping, and I'm paraphrasing, to turn the state red. I mean, that's what you want from your chief law enforcement officer in the state? I mean, that is not your role.
Right.
And so you can understand the judges saying that is a bridge too far. That is, you've now crossed a line.
That is a good point, and she made that remark, the "Turn New Jersey Red," on a right-wing podcast. That's the forum that she chose after, ascending to that office to make that nakedly political statement. Thank you so much, Andrew. Always a pleasure talking. Thank you for helping, give everyone insights about the grand jury process and why this news is so, so remarkable.
Thanks so much. Nice to see you. Sorry, as I say to every time I do these things, sorry to be talking about this. I just want to say for the people who are listening, thank you very much. It is the news these days is so difficult, and I think it's really great and commendable that people are staying engaged.
Mm, absolutely. And I think to add to that, Andrew, one of the big takeaways of this story about the grand juries is that common people have frustrated the designs of the federal government when they think that the occasion called for it, when they felt that the evidence did not add up, that this wasn't a true bill. And it really just goes to show where we hear so much about pretensions of absolute power and Trump floating these statements about maybe the people want a dictator if it means less crime. That the news about a grand jury really does call attention to our institutions, and and even beyond the abstractions of institutions, everyday people exercising the power that they have. So thank you everyone for watching. If you want to see the full video, if you logged on late, I will be posting this on All Rise News. You can subscribe to both of our newsletters on the top left of your screen right now. And I hope to do this again soon.
Great. Thanks so much. Take care.
You too. Bye bye.